Okay, this is video lecture 3 for the makeup class from Wednesday, September 21st. We are in the middle of talking about this rule, Federal Rule 412, otherwise known as the Rape Shield Rule. The last section of the rule we have yet to talk about is 412C. And 412C, which is very similar to most state rules, we see here no matter whether it's in a criminal case or a civil case, if a defendant or a party in a civil case, right, intends to offer this kind of evidence about a victim, notice has to be given to the court, notice has to be given to opposing counsel, and to the alleged victim 2 weeks before trial. And any hearing under the federal rule held to determine admissibility is done privately in chambers or in a cleared courtroom, and the proceedings are sealed. So all of these things, pretty self-explanatory, done to protect the privacy of the victim. So very protective, and no one is going to be surprised by this evidence at trial. Okay, so now that we've gone through the nuts and bolts of the basic rule, we're going to talk about the Cassidy case, Olden, and Platero. Now, these three cases actually just illustrate the constitutional balancing under Rule 412B1C. So these cases are actually really directed just at that constitutional catch-all part of the rule. Now, Cassidy first is a Connecticut case. This is the one where the victim and the defendant gave very different descriptions of the sexual encounter that happened. Both agreed that the two knew each other before the night in question and in fact had had consensual sex before, and that she willingly went to his house, went upstairs to his bedroom, undressed, and got into his bed. And at that point, she was willing to have sexual relations with him. So those were the facts both sides agreed on, but then she contended that he yelled at her and threatened her and in fact forced her to engage in non-consensual sex. Cassidy, the defendant, on the other hand, testified that the sexual encounter was completely consensual, but that right afterwards she, in his words, went crazy and started screaming about her husband who had died in the Vietnam War. Now, Cassidy here wanted to put on the stand a witness who claimed he had had a very similar experience with this victim about a year before. The trial judge ruled the testimony inadmissible because it was barred by Connecticut's Rape Shield statute, which was essentially identical to the federal rule. It did include this constitutional exception that stated that evidence that is, quote, so relevant and material to a critical issue in the case that excluding it would violate the defendant's constitutional rights may be admissible. Now, Cassidy at trial and here on appeal is claiming that excluding this evidence violated his constitutional rights. He said it violated his rights both to due process under the 14th Amendment and his right to confront witnesses under the 6th Amendment. So in order to consider Cassidy's appeal, the appellate court is going to have to do this required constitutional balancing. And there's an interesting tension here about whether any probative value versus prejudice weighing should be done as a part of the constitutional analysis. If you look at footnote 2 on page 166, you see that the Connecticut Appellate Court says that probative value versus prejudicial effect balancing would be completely inapplicable if a court found that exclusion of the evidence would violate a defendant's constitutional rights. The court here says the only balancing that should be done in that context is balancing the state's interest in protecting the victim against the defendant's constitutional right that's at stake. There certainly has been some legal scholarship on this issue. There's a good argument, I think, that maybe under the surface, courts are going to keep this prejudice against the victim issue in mind, but that it might not be overtly discussed in an opinion or written about in the opinion. It just gets sort of folded in on the state's interest side of the scale. This might be easier to do in a case that implicates the due process right to put on a defense. That is a more vague right than the Sixth Amendment confrontation right about being able to cross-examine witnesses. Now here, Cassidy offered the testimony of his witness to establish what he called a pattern of conduct, the conduct here being presumably that the victim invariably got upset about her dead husband while having sex. This is really more of a due process argument than a confrontation clause argument. There really isn't a confrontation argument here in Cassidy because there isn't a cross-examination issue here, at least that we see. Of course, that's in contrast to the next case in the book, Olden, which is really a straight confrontation clause case. And there you saw the Supreme Court say that any possible prejudice would have to be extreme and not speculative in order to rise to the level that would exclude evidence in the confrontation context. But back here to Cassidy, the appellate court here apparently felt that testimony about one similar episode a year earlier did not establish enough of a pattern, quote, and therefore was only marginally relevant, in their words, and not critical enough to outweigh the state's interest in protecting victims' rights. The court also points out that there was no allegation of sexual assault made by the victim after the other alleged incident. The court said, well, if that had been the case, then the relevance link would have been more solid. I think the relevance point here is at least debatable, though. I mean, if we believe the story of the proffered witness, Cassidy's witness, especially with the specificity of the description about the victim's upset over her husband being killed in Vietnam, probably most of us would admit that Cassidy's story here does appear more likely to be true after hearing about the earlier incident. So probative value, you know, there's at least an argument there that it's got some significant probative value, in fact, and more than just marginal relevance. Okay. Now we're going to see the confrontation clause in Olden versus Kentucky, which is a Supreme Court case from 1988, whereas Cassidy sort of threw the confrontation clause in his appeal. Clearly, this Olden case is definitely squarely in the confrontation clause box here, the Sixth Amendment. And Supreme Court decision from 1988, per curiam opinion. That means there isn't a listed author of the opinion. Okay, so this is another criminal sexual assault case involving the defense of consent. After the incidents described in the facts, which we saw were described very differently by the alleged victim and the alleged perpetrator and other witnesses, the defendant drove the alleged victim, Matthews, to the house of his half-brother, Bill Russell. Now, the defense claimed that Matthews had made up her account of the sexual assault because she wanted to protect her relationship with Bill Russell, who had actually seen her get out of the defendant's car and might have been suspicious about what she was doing with the defendant. So the court recounts some of the inconsistencies in the alleged victim Matthews' story over time, and the court also points out the strange result at trial, very strange, in which the jury acquitted the defendant of kidnapping and rape, but found him guilty only of forcible sodomy, for which he got a 10-year sentence. Now, the defense on appeal here alleges that Matthews and Russell were having an extramarital affair back at the time of the incident, and that by the time of the trial, the two were actually living together. So at trial, Russell, the then boyfriend of the victim, had testified for the prosecution, and Matthews testified that she was living with her mother, which actually wasn't true. So the defense wanted to cross-examine her, the victim, Matthews, both about the alleged affair she had been having with Russell at the time of the incident and about the fact that she and Russell were in fact living together at the time of trial. And the trial judge excluded the evidence concerning the affair and didn't allow any cross-examination about her living situation. Okay, so this case before it got to the Supreme Court, had gone through the Kentucky Court of Appeals, which had upheld the conviction. That court agreed that the proffer evidence was relevant and not barred by the rape shield law, but it did uphold the trial court by saying that the evidence's probative value was outweighed by the possibility for prejudice. And there's a quote here from that Kentucky appellate opinion that's on page 168. The Kentucky Court of Appeals said, there were the undisputed facts of race. Matthews was white and Russell was black. For the trial court to have admitted into evidence testimony that Matthews and Russell were living together at the time of trial may have created extreme prejudice against Matthews. I couldn't figure out exactly the prejudice the Kentucky court was getting at there. Were they thinking that a Kentucky jury in the 1980s would assume that Matthews must have consented to sex with the defendant if she would consent to sex with another African American man? That was left unclear. Or were they thinking maybe that a Kentucky jury just basically would condemn Matthews altogether for being in a relationship with Russell, an African American man? They do use the words extreme prejudice there. But so they essentially said, that it it did fall squarely within the rape shield statute, but prejudice outweighed probative values, it substantially outweighed. In any event, it got all the way to the U.S. Supreme Court, and the Supreme Court here held, look, this is actually constitutional error, excluding the evidence about the victim's relationship with Russell because it prevented the defense from conducting a full cross-examination of the victim Matthews here in violation of the Sixth Amendment Confrontation Clause. And the court points out that the Kentucky Court of Appeals didn't even mention the defendant's Confrontation Clause right in its opinion. So after finding that there was a constitutional violation here, the court does the harmless error analysis, which requires the reviewing court to assume that the damaging potential of the cross-examination had been fully realized at the trial court level, and then imagine if it's at all possible to say that the error was harmless, i.e., would it have likely changed the outcome of the case? And here the court finds that it was not a harmless error, and they reversed and remanded. So the first question I want to make sure that you're clear on here is, does this case mean that rape victims can always be cross-examined about their current sexual partners on the grounds that any victim might have fabricated an assault so that his or her current partner would not be jealous? And the answer to that is no. The key fact here is that the alleged boyfriend of the complainant saw her get out of the car, saw her get out of the defendant's car. So Matthews' motive to fabricate in order to explain why she was with the defendant was greater than it would have been had she just reported the sexual assault to the police before her boyfriend knew anything about it. Also, we have here in Olden the additional fact that Russell had testified as a prosecution witness, so the evidence of his intimacy with the complainant could have also shown his bias as a witness. Now, moreover, even though the Supreme Court didn't make anything of it here in the opinion, there's a good argument that the prosecution lost its right to object to the evidence after it elicited a statement from Matthews on direct that she lived with her mother, when in fact she lived with Russell. Also, here I think we should note that it wasn't necessary for Olden to introduce evidence of the complainant's sexual history per se. Right? The important fact was that she and Russell had a relationship of such a nature that she would potentially feel the need to fabricate a story as to why she was out with Olden on this night. So Olden has special facts, shouldn't be construed to mean that the right to confrontation has been denied if a court doesn't allow free cross-examination of a sexual assault victim about current sexual partners. But Olden does illustrate that the Confrontation Clause can be construed in a fashion that might allow defendants to put on evidence that would otherwise be excluded by rape shield laws. There are other kinds of cases in which evidence of an intimate relationship is relevant to motive to fabricate accusations, and in which a defendant can plausibly argue that the Confrontation Clause requires that the evidence be received. Okay? Um, so on this slide, I have three other kinds of cases that might also sort of allow this constitutional catch-all to be used. So I have this Oregon case, State versus JLo, 1976 case here. A child here was alleging she was sexually assaulted by the defendant, and the appeals court found that the defendant's right to confrontation required admission of evidence that the defendant had learned of the child's sexual misconduct with his son and other children, and had in fact threatened to tell her parents. And this evidence, of course, could have shown the alleged victim's motive to testify falsely and falsely accuse the defendant. Okay, the next case, Commonwealth versus Black, that's a 1985 Pennsylvania case. Here it was held that the state rape shield law violated the defendant's right to confrontation, where the defendant was asserting that he had tried to intervene when he found out about the alleged child victim's sexual relationship with one of her brothers. So again, there was a claim here that there was a motivation by an alleged victim to fabricate a complaint against a defendant. And again, constitutional confrontation rights were implicated. And this last one, Lewis versus State, 1991 case out of Florida. Here, a defendant's right to confrontation was found to be violated when a trial court excluded evidence that the alleged victim, who was the defendant's stepdaughter, had fabricated the charge to prevent the defendant and her mother from discovering through a gynecological examination that she was sexually active with her boyfriend. Again, a case reversed where this kind of evidence wasn't allowed to be put on by a defendant. Okay, that brings us to United States versus Platero. This is just a note case in the note on page 170. 10th Circuit case from 1995, so 7 years after Olden. This is a very bizarre case. In my opinion, I couldn't get around the fact that the defendant here was impersonating a police officer when all this happened. I kept wondering whether that was at least part of the reason the jury convicted him here. It would have certainly affected my decision making as a juror, I think. The fact that he was impersonating a police officer. But the facts here revolve around another sexual assault, this time in violation of a federal statute because it took place on a Navajo reservation, in which the defense was consent. So the defendant was a security guard, but here he pretended to be a police officer and stopped a car late at night driven by Vernon Laughlin, supposedly stopped him for weaving on the highway. So Laughlin and his passenger, Susan Francis, were coming home from a bar, and there was apparently an issue of him, Laughlin, driving intoxicated. So Platero told Laughlin he was going to give him a break, told him to take off walking home. And then when Laughlin was a little ways away, Platero ran up to him and said, "Oh, by the way, I'm arresting your passenger here, Francis, for being uncooperative." Platero then took Susan Francis off in his car, and according to her testimony, he handcuffed her, raped her twice, and forced her to have oral sex with him. And now he admitted all this sexual contact, but claimed it was consensual. Kind of hard to imagine how it could truly be consensual under the circumstances here, but that was his defense nevertheless. So he then took her back to Laughlin's car, and Laughlin actually was there because he had walked back to the car and fallen asleep in it. So as soon as she got back in the car and Platero drove away, Francis told Laughlin she had been raped, and he took her straight to the hospital. So now, at trial, Platero wanted to put in evidence that at the time of the incident, Francis was having an affair with Laughlin, and because he saw her buttoning her blouse and fixing her clothes when she got out of the security car, Platero is alleging she made up the rape story to protect her relationship with Laughlin. So essentially a similar theme to the Olden case. Now, also similar to Olden, Laughlin and the victim were living together by the time of trial. But Platero wanted to put on evidence that Laughlin and the victim were having an affair at the time of the incident, when the victim was married. And the trial judge kept that evidence out, and Platero was convicted. So now this case went up to the appellate level twice. The first time, the appeals court remanded and said the admission of any of this evidence depended on whether there was an existing romantic relationship between Frances and Laughlin at the time of the incident. If there was, then Platero should have been able to cross-examine about it. Now, on the remand, the judge made his own determination that no sexual or romantic relationship existed at the time of the incident. So he just let the conviction stand. He essentially said, all right, appeals court, if you say admissibility depends whether there was a romantic relationship, I say there wasn't, and so I'm letting the conviction stand. Platero appeals again. Now, on the second appeal, Platero said that this whole issue of whether there was a romantic relationship shouldn't have been decided by the judge, but instead should have been decided by the jury under that 104B standard of whether some reasonable jury could find the fact to be true. So Platero said, look, this judge shouldn't have just decided on his own, made up his own mind that by a preponderance there was no romantic relationship. He should have said, you know, could some reasonable jury find under these facts there was a romantic relationship? And the appellate court agreed. And not only that, the appellate court not only agreed that the standard should have been that conditional relevance 104B standard, but they went further and said, by the way, we're going to find affirmatively that a reasonable jury could have found that fact, so that not allowing the cross-examination was a violation of the Confrontation Clause. Okay, so on this slide, first let's talk about the substantive evidence issue. We know the alleged relevance of the affair was to show that Frances had a motive to lie and claim she was raped, so Laughlin wouldn't think she had consensually fooled around with Platero. So Olden is our constitutional precedent here. In looking at whether evidence of the affair here is admissible under the Olden case, we could look for facts that might distinguish it. So first, in Olden, the boyfriend, Russell, saw Matthews get out of the defendant's car, so the defense argued that her rape claim was an attempt to cover up her consensual sex with the defendant. Platero was making a similar claim. But here, Laughlin had no reason to suspect that Frances would have been voluntarily going out with Platero. As far as we know, Platero was a complete stranger to them, so it's certainly a weaker argument here than in Olden, where it was obvious that the victim had been with the defendant of her own accord. Somehow he was driving her home. Laughlin did supposedly see her buttoning up her blouse when she got back, though, so if she hadn't said she had been raped, conceivably he could have been jealous, so maybe a weak similarity there. Another similarity is that both boyfriends testified as prosecution witnesses, so there's an argument in both cases that their intimacy with the victims might have biased their testimony. A difference, though, in that testimony is that the prosecution in Olden elicited testimony from the victim on direct that she lived with her mother, when in fact she lived with Russell. And like I said, arguably that in itself maybe should have forfeited the right to even object to cross-examination revealing that she lived with Russell. But apparently there wasn't testimony like that elicited on direct from Laughlin in Platero. So that's all of the substantive issues here in Platero. But next, I just want to talk a little bit about this procedural evidence issue. So on this second appeal, the appellate court finds that the jury should decide whether the affair took place, so Rule 104B would have been the proper one for the judge to apply. And, you know, the 10th Circuit here notes that in the interim between the first and second appeals, Rule 412 had in fact been amended, explicitly moving the preliminary fact questions underlying the use of these exceptions from the judge under 104A to the jury under 104B, as long as sufficient evidence existed to allow a reasonable jury to conclude that the fact was true. So now I have a rhetorical question on the slide about, well, whether allowing these issues to go to a jury with only the sufficiency standard of 104B and, instead of requiring a preponderance of the evidence determination by a judge is a good idea. Certainly it's important to protect the defendant's right to a trial by jury, but I think one has to acknowledge this 104B sufficiency standard definitely weakens one of the mainstays of Rule 412, which is this overall procedural protection for alleged sexual assault victims. Under Platero, judges must allow allegations of prior sexual conduct to come in if a reasonable jury could find that the conduct occurred when the conduct could provide a motive to fabricate, even if the judge doesn't personally believe that the sexual conduct or the underlying issue is true or took place. So there's a danger here that victims could be deterred from continuing with cases once defendants raise potential bias issues, since judges have limited power to exclude relevant sexual history once that bias link is made, even if the judge himself or herself thinks that the sexual history evidence is fabricated. And that is the end of our discussion about Platero. I'm going to end this video here and start with Rule 413 in the next video.